So we're looking forward to a very exciting program this morning. First, I want to introduce our moderator for the program, Mike Hawes. Mike is an intellectual property partner at Baker Botts. He has a BS in electrical engineering from Rice, JD Harvard. He started his career as a law clerk to Honorable William Bryson of the U.S. Court of Appeals in D.C., but then he evolved into a practice involving litigation planning, discovery strategy, and preparation and execution of trial, including handling negotiations and cases dealing with patent and copyright infringement and trade secret misappropriation, antitrust violations, and other violations of intellectual property provisions of contracts. So our featured speaker on the topic is Dr. Elvir Causevic. Dr. Causevic is Managing Director and Co-Head of Houlihan Lokey's Tech IP Advisory Practice. Dr. Causevic was formerly founder and CEO of Blackstone IP, a boutique investment bank focused on valuing and trading tech and IP assets. That entity was acquired by Houlihan Lokey last year. Prior to that, he was the head of IP strategy practice at Ocean Tomo. Before that, he had a very active and engaging entrepreneurial background. He is a named inventor on more than 20 patents and patent applications. He was assistant professor of applied mathematics at Yale University. In my opinion, the most impressive feature on your resume, Elvir. BS, MS, and Doctor of Science in Electrical Engineering from Washington University and a JD from University of California, Hastings. So with that, I want to welcome our speaker and moderator.
Hi, good morning. Very happy to be here. Thank you for a warm welcome. There were several folks from NACD and others took me out to dinner last night, which was really nice to prepare. We had some lively discussions. We disagreed on everything, so it was a lot of fun. The topic today, nothing better to get your Friday morning going than talking about fiduciary duties. But the talk is really more about intellectual property, and why it's important is there's some interesting things going on in our country, as I'll show you. Silicon Valley grabbed the innovation mantle from everybody else. And there's so much great innovation that happens everywhere in this country, and Houston in particular, and Texas broadly, is one of those places. I just wanted to highlight a few things that point in that direction as I go through this. Here's Houlihan Lokey. We're a publicly traded bank on the New York Stock Exchange. As you can see here, we beat Goldman Sachs by one deal. So, yes. And we do most of everything. I'm in this group here, financial advisory. So we did 1,001 opinions, which means it's 1,001 sleepless nights on fairness opinions. Here's some of the folks that pay attention to IP. This is who I work with. A number of companies. You'll see a variety of different companies. What you don't see is a lot of companies that do innovation and have a lot of IP, but are not very active kind of in the intellectual property markets, and I'll explain why in a bit. You see some of the private equity funds and larger banks down below. So how much IP is in any one company? Right? People think, we don't really have any IP, meaning we don't have 10,000 patents. But a lot of companies, in fact, do have IP and keep it protected, which is the reason why they're successful. Right? They build equipment, they do whatever they do, and that intellectual property is kind of in the background. What I'm trying to do is make sure that intellectual property comes to the foreground so that we talk about it, especially at the board level. Right? It's absolutely critical to talk about this at the board level. And here's an example of the public markets, how much they report intangible assets and intangible assets. And you'll see that 87% of the value of our companies is in intangible assets. I'll flip through a few more statistics just to wake you up that are really interesting. But there's a point to these statistics, right? It's not just obvious here.
So
let me start.
Elvir, as you walk through this, I just want to remind everyone, there are question cards on your table. So if anything Elvir says gets you inspired to give me a question that I can quiz him on later, I would appreciate it. So please take a look.
I wanted to start with, for example, oil and gas, right? We're in Houston. Let's talk about energy. There's so many other awesome things that are happening in Houston, right? There's no question. There's so much innovation, not just in Houston, but in the Tri-Cities area, right? Certainly with Austin and all the semiconductor industries, with the military bases, with the hospitals, with medical device industry, in so many different areas that are here. But I just picked oil as a good example of an industry that's now going to face an even bigger pressure around technology and intellectual property. First of all, some great innovation here. Let's just talk for a minute about the oil and gas industry. So I'm in San Francisco, right? It's not popular to mention the words oil or gas, right? Certainly not together, right? Which is a little naive, right? It's a little naive because if you take a look at the bill of materials of any product, and you just say, how much is energy, how much is labor, how much is transportation, how much is this, how much is that, you'll see that 30%, 80%, 73%, 64%, it's energy. So yes, oil and gas is energy. There's other, obviously, forms of energy. But I think we're being a little naive around energy, and we're being a little unappreciative about the boost in the economy we got from the innovation that came right out of here. Just shale. Just think of shale. And what it's done for our entire economy. And now think of how that entire business is changing. And how it's changing is it's basically starting to become digital, right? It's digital oil. It's everywhere. It's in transportation, it's in every step of the process here. Now what you see is this merger of basically semiconductors, hardware, software, and everything else, right? Cars used to be cars. Phones used to be phones. Now we have cars that are phones and phones that are cars, right? I always say Bosch is a big client of ours. You know, they're a tier 1 supplier for the automotive companies. And I always say when you have a carburetor company building software and a software company building cars like Google, it's good to be in my business, right? Because there's a lot of crossover back there. But with that comes some risks, and I'll highlight some of those that I think are important, which is how do we manage this innovation? How do we make sure we don't just give it to a silver platter to others, right? I think if you invent something, and so did our founding fathers because they put it in the Constitution, if you invent something, it ought to be yours, and you ought to be able to get some value out of that, right? And you shouldn't just allow others to just pilfer it and take it away. Here's a survey from Department of Commerce that talked about how much employment is in the IP-intensive industry. So it's about 40% of people that are in the IP-intensive industries, and about 38% of our GDP in 2014, that's the latest data, comes from IP-intensive industries. That's a lot, right? So it's in your company, so 40% of people here are dealing with businesses that have intellectual property. The problem is we don't talk about it. When we don't talk about it, then people find a way to take advantage of that. Here's the wages. So these are good jobs. Look at this. Here's the IP-intensive jobs, premium on salaries over the average economy. So at any compared, college degree, or no college degree, no college degree, if you're in the IP-intensive industry, here's the premium that you get, 50%, right? On patents, 80%. So these are good jobs, right? We want these jobs. There's a lot of them. We want them, but let's see what we're doing about those. So here's a bit about what is intellectual property and what's happening in the market. It's in the Constitution, Article 1, Section 8, Clause 8, the Congress shall, and basic forms of IP, patents, trademarks, right, brands, copyrights, and then trade secrets. Trade secrets meaning it's intellectual property that you don't necessarily publish, you just keep it secret, and you got to work hard to keep it secret. Lots happening in the last few years. America Invents Act came out, which is the new patent law that gave our patent office huge rights. Not that different from our EPA having huge rights, right? So we've now pushed we pushed a lot more power to the bureaucrats and away from the companies, away from the deal making, and away from the courts. Not a good thing. Lots of Supreme Court decisions that really changed how things happen, and a couple of them that are important. There's one called T.C. Heartland that changed the venue laws, so you can no longer bring cases where it makes sense. You need to bring cases in certain places, meaning you can't bring them to the Eastern District of Texas, which is one of the venues that used to be very popular for patent infringement. A lot of talk about patent trolls, right? Patent trolls, you've heard all about patent trolls. All of that stuff is paid for by people who don't like patents, right? So are there patent trolls? Yes, absolutely. There are these really mean people who go buy junk patents and they go sue everybody. But there's 100 of them. The total cost is a few $100 million. right? It's just cost of defense, right? It's the same as slip and fall people, right? People that go to Walmart and fall down and they sue everybody and whatever. The employment trolls, right? Somebody that works with you for 6 months and claims harassment. It's like there's always going to be abusers of the legal system, and patent trolls are no different, right? However, the story that's been told is anybody who owns a patent is a patent troll, because as soon as you try to enforce your patent, you're a patent troll. That's really dangerous, right? Because what's really happening is if you're the person that uses a lot of technology, like big tech, but doesn't invent a lot of technology, despite the label, then that's what you want, right? That's what you want. You want to say all patents are bad. All energy is bad, right? All oil and gas is bad, and this is good, and this is bad. All patents are bad, and we should just have, everybody hold hands and sing Kumbaya. Bad idea. The massive push from big tech and kind of massive infiltration of all of these various government agencies. And I'll show you some statistics there. There's a new case in the Supreme Court right now, coming out of here, all states versus Greens Energy, to actually try to bring back some of these provisions, try to take back from the bureaucrats in Washington, take back some of these rules. This is a kangaroo court, right, that kills patents, right? What happened is this law established basically a little patent-killing court inside the patent office that now changes with every administration, right? So we had 8 years of a particular administration. They just got, that court got stuffed. The kill rate for patents, if you challenge it, is 80%. This goes to the heart of the American economy, right? This is not good. And part of the reason I'm here, I wanted to talk to boards, because the boards have the ability to say, hey, wait a minute, what are we doing with our patents? Are we protecting our stuff? Who's stealing our stuff? Right? What are we doing about these things? There's a lot of talk about FRAND. It means fair, reasonable, and non-discriminatory, meaning if you have a group of companies that invent something like 4G LTE technology, and then you have a group of companies that implement that, you want to make sure that these two groups talk fairly with each other, right? That there's some reasonable way to do that. And the pendulum has been swinging in one direction. Now it's finally starting to come back. The new administration has been very helpful. We just got a new head of the USPTO approved. That's very nice. And then, of course, this is global. Europe now has a court called the Unified Patent Court that's about to launch. It's similar to our Court of Appeals for the Federal Circuit. You're nodding your head. It's about to launch. It's been about to launch for a long time. It's been 5 years out for the last 25 years. China. China is becoming very serious. They're taking all of our retired judges and building a patent system that rivals ours, right? Well, it's only fair. We did the same thing to England. Right? So we created our own country, and we built our own patent system, mostly so we can say that the British patents were invalid, so we can do our own cotton gins and everything else, right? So, what goes around comes around. But it doesn't mean that we should just lay down and just let everybody just take our stuff, right? That's not a good idea. And that's, at the end of the day, what's happening, right? Because certain innovators and implementers here are tussling politically to make our intellectual property less valuable. Others are taking advantage of that. And I think that's a serious issue, and there's a lot there. So here's a little group called the LOT Network. I call this the self-inflicted wounds. So here's propaganda. Not that dissimilar from North Korea. Eliminate the patent troll threat. The evil patent trolls, they're going to eat you and take your children and do all of these other things. So what you should do is you should just put all of your patents together in a club and then basically say that, again, everybody hold hands and sing Kumbaya. And then there's the Electronic Frontier Foundation. You can't read it on the top. These guys are left of Marx, right? This is the free software, free everything, right? Just everything should be in the public domain. Everything should be open, and in my view, totally un-American. But they convinced this little company called Twitter to launch this patent, what do they call it? Patent Innovators Agreement. Basically, they said, we will never use our patents against anybody. Oh, that's a good idea. So here's this guy on Charlie Rose. This is Mark Benioff. He's the founder and CEO of Salesforce.com. Anybody use Salesforce? So he goes on Charlie Rose and he says, I got to tell you about something. This was only a couple of years ago. I couldn't believe it. I literally could not believe it. I was just stoned, sitting in my chair going, I can't believe he actually said this on national TV. He says, we got this new thing. It's called, where's my next slide? Yes, are we moving the slides? Here it is. We have this new thing. He literally said this. It's called Chatter, and it's exactly like Twitter, except for enterprises. And now Twitter, if you look at their stock, when was the last time Twitter made money? Never, right? It's never been profitable. And these guys have the largest tower in the western United States, right next to our office. Blocks my view of the sun here. So what happens, it's a completely self-inflicted wound, right? You go out there, you get excited about, a myth, and then you go and make this big pronouncement, and then, of course, people take your stuff. Who else took their stuff? Tencent, Baidu, right? Alibaba, everybody else, right? Why would you do such a thing? Are we moving? Can you move the next slide? Great. So here's another one. Remember I told you how these are really good jobs? The patent jobs, they're really nice. Here's a non-IP intensive industries indexed to 100, right? How jobs grow, indexed employment. Here's our patent intensive industries. Well, that's not good. Didn't we just say these are the best jobs? They have a 70% premium, right? They protect all of this stuff. So this is why we got to talk about this stuff. So we can go to the next one. I think this is now completely dead. Yes, can you just go to the next slide?
Next slide.
I really want to drive this point home. Great. So how do you make money from these patents? It turns out that a lot of companies have a lot of patents that they develop, and they use a little sliver in their industry. And I thought, okay, the way to get attention placed on this is to make sure they're actually making money from this outside of the core business. Right? So the idea is you have non-core IP, or you have IP that you're using here, and you could be using it over there. Just like if you have phone technology, you're focused on phones and everything else, but now smart oil fields are coming on board. If you're a smart phone company, right, with a lot of phone patents, you'll jump into the car business, into the oil business, into everything else. So that's the idea. Can you use it everywhere else? Well, the first one is, of course, risk exposure. Right? You actually are infringing somebody's patents, or somebody's infringing your patents. That's good. Or another way to make it is, one of the people far removed from your industry is in a big battle over somebody else in their industry, and you're over here, and you got some weapons, and they want to fight. That's a nice, honorable way to make a living. Right? Is to arm them, right? To say, okay, look, Medtronic and Boston Scientific, you are now starting to put this implantable defibrillator, which needs to talk to the outside devices. Here I am, XYZ company Ericsson. How about I give to one or both of you, whoever's the highest bidder, and 12 other people, I'll give you some of my patents to sort out your market battles. Defensive is another one. People just want to buy, by the same token, they want to make sure that they can defend themselves when people come in. And then revenue generation, right? You can actually go and set up a licensing program. So this thing, it's called an NPE, which means non-practicing entity. So Washington loves this, right? And big tech loves this. Non-practicing entity means you're a company that doesn't, quote unquote, make anything. You're just an R&D shop, like Baylor University, right? Like a whole bunch of different entities, like NASA, right? You don't really make anything, right? You kind of buy everything. You just have 10,000 patents, but you really shouldn't be out there enforcing those, right? So this idea of you don't make anything, Obama actually said it in a State of the Union address about 4 years ago. He literally said this, and I learned that line cost $7 million, right? So if you need him to say that, and he said literally, the quote was, there's these patent trolls that are a drain on our economy, and they don't make anything, right? Just like all of our research labs, right? Just like a Hughes research lab, and just all of these other companies that, yeah, it's true, they don't really make anything, other than they invent our next generation of technology, military technology, oil and gas technology, telephone technology, everything else, right, that we have. So there are companies who are set up out there, respectable companies. Dolby, GE has an entity, they're a big client of ours. IBM does this internally. All of these people they're operating, running businesses, and then they have the licensing business. The second you take that licensing business inside of GE and you take it outside, now you're the dreaded patent troll, right? Not a good idea. So why should we force some semiconductor company to ignore their patents? They're not allowed to really sell them to anybody to enforce on their behalf. So this is the kind of cycle that gets set up. Let me flip. Oh, it's starting to work. All right. There is a good, ugly, and bad way to sell your patents, right? Or to monetize your technology, right? The good way is you think. As a board, you do a strategic alternatives analysis. You ask your management team to prepare, and your outside counsel and advisors to say, hey, do we have something here? Right? We keep talking about all this great technology that we have. What is it really worth? Can we use it somewhere else? Does anybody else care about this stuff? Is there any way to make extra money off of the, we're pumping $150 million a year into R&D, what are we getting out of it? My old boss used to say, if I go to a Coke machine and I put in 50 cents and nothing comes out, I walk away. I come back, put another 50 cents, nothing comes out, I walk away. The third time I put in my 50 cents, nothing comes out, I kick the machine, right? So how's your R&D machine doing? What is it producing? What is it generating?
Does it need a kick?
I'm sorry?
Does it need a kick?
Yeah, exactly. Does it need a kick? And you don't want to go to market with something small. You don't want to be pigs get fed, hogs get slaughtered. You don't go to market asking some ridiculous prices, right? That's where we have some of these patent wars, these ridiculous prices that show up. And then you start going to friends and family and say, hey, would you guys like to buy this stuff? Your suppliers, your customers, folks like that. Here's the bad. You try to monetize patents that are about to go to the garbage bin. Like, these are kind of old, really junky. Let's see if we can make some money out of them. Right? That's not a bad. Nobody wants to buy your junk, right? It's like a garage sale, right? The good stuff sells, the bad stuff goes to Salvation Army. Same with your patents, right? The other one is to start immediately out of the blocks. Don't talk to anybody, but just start hitting people right in the head with your patents. It's a bad way to do it, right? Ask for an excessive price, and then try to do it yourself, right? Just like most great things, just get some professionals who can help. And then there's the ugly of the patent market, and this is what big tech and others latch onto. There's this idea called privateering. It came from the Spanish and English kingdoms when they paid pirates to go rob the other guy's ship. They didn't really want the stuff. They just wanted to sink the other guy's ship and take it, right, and hold them. So the way that works is if you have a big portfolio of assets, say 10,000, and you really should do one license with Apple, instead what you do is you take your patents, you separate them into 5 groups, you sell 4 groups off to 4 different people. All 4 of them go attack Apple, and then you over here, you yourself attack Apple. Now you're coming after them from 5 sides with basically the same stuff, right? It's just bad, right? And that's what gives bad press to everybody else who is in the IP-intensive industry, where we get the 70% premium on salaries, where we have our national interest at stake. I'll give you one example of a company that I advised called MIPS Semiconductors. Small company, about 100 million, traded about 125 million. The story there is we pitched the board very hard that there's value in the patents. And the board, of course, ignored me for 6 months. So I kept coming back. And then I finally convinced the board that indeed the patents are worth $300 million or so. And then the first thing the board did is fired me and said, okay, if they're really worth $300 million, we don't want you selling them. We need a real bank selling them. So they hired JP Morgan, who goes out there for 6 months, creates nothing. They used to have offers for $100 million without the patents, and now they got offers for $100 million with the patents. So then I got hired back again. JP Morgan was successful selling their patents for $100 million. I'm sorry, selling the business, the entire business, minus the patents for $100 million. We kept some in there. And then my team and I, we sold the patents for $350 million. So that board was very happy, right? The investors were very happy. The CEO is friend to this day, right? He's got an apartment in San Francisco and a house here and a place there on the back of that. But it took a little work. It took doing something counterintuitive. So Broadcom was MIPS's #1 customer. So I talked earlier about the good way to monetize your patents. We went to them first and said, look, guys, we're going to be selling the company. We don't know who's going to end up with this. You should take a license to all of our stuff, everything we've got. So you're buying a lot from us right now. You don't have a license, but you got to pay us an arm's length license. So once they did that, they paid us 10 cents a chip, basically. Once they did that, then we had the whole world. 11 companies bought these patents and put together. So it was Intel, Google, AMD, ARM out of England. Just a whole set of companies ended up buying them because we set this precedent here. So there's a way to do it. There's a way not to do it, which is just to go hire a big bank and try to get stuff done. It just doesn't work because you can't articulate the value of these patents. Or there's a way to think of a 1-2 step and say, well, let's do a deal with a friend, which nobody expected, and then that sets the price so that nobody else can complain about the price here. So just a couple of quick notes from the board perspective. I think this is really important. I actually think boards have fiduciary duties to do this, right? It's not just we'd like to do it, we'd want to do it, I will get around to it. I used to live in little town in Missouri where I spent most of my life, Aurora, Missouri. Right in the corner there in the Ozarks between Arkansas and Oklahoma. And we went to Silver Dollar City, and there's this thing you can buy in Silver Dollar City. It's a round thing, and it's called a tuit. You know what it is? Yeah, you give it, it's a round tuit. So you can give it to people, so they say, I'll get it done when I get around to it. And you give them a round tuit, and they can get it done. So here's a round tuit for boards. Can't say you don't know now. Of course, you have your various duties, right? And luckily, there's the business judgment rule that will help with the boards. But the idea is, if you're selling the company, you really want to set up, of course, a special committee, so you have a careful process. So you have a duty to be informed, right? That's your number one duty. And then on the Revlon, you have special duties that show up, which basically what happens is, the court in Revlon said you no longer care about the long-term value of the company to the shareholders. The board members become the short-term auctioneers, getting the best price for any asset that you can get. So all of a sudden, if your long-term strategy on patents is, we don't want to pick a fight, we want to be a good neighbor, we want to do all of this stuff, Revlon tells you by law you actually have to look at all of your assets, just like if you have a building, right? You got to get money out of that asset. And of course, you have a duty to inform yourself. In Silicon Valley, what we're seeing is this real issue of duty of loyalty. Because of this, there's a case came out a couple of years ago, Trados, that talked about people that basically wanted to do a deal or didn't want a deal, board members that wanted to do a deal or didn't want to do a deal because of themselves, right? Because it's good for them. It's good for their private equity fund, not good for the company and the shareholders. Well, I saw this firsthand a dozen times in Silicon Valley, including with MIPS, where they say, well, we really don't want to do anything with these patents. I'm on 3 other boards. It's kind of, I just don't want that label. I don't want to be a patent troll. I just don't want that label. It's just too much risk. Ooh, that's dangerous, right? You can't do that. You got shareholders to worry about. You got me, right? My 401k is in there. My mom's 401k is in there. So you can't really, it's not up to you to say, well, I'm on another board. I really can't do that. I don't care what board you're on. You have a duty here. And you have a Revlon duty right here, right now, to figure out what to do with these assets. So here's a bunch of deals that did happen. You'll see here, hundreds of millions of dollars of value. There's some mega deals, right, that are hard to replicate, $5 billion and $1 billion and $4.5 billion. But lots of these deals in the hundreds of millions of dollars, right? Reasonable size deals. And I went and wrote a paper about this. It was published in the Berkeley Business Law Journal, which was a shocker because they're kind of the top of the anti-patent crowd. On the patent side. However, I sneaked into the Business Law Journal. So they don't really talk to each other, which is great. So now I can say, hey, look, Berkeley says patents are good. But the idea here is that there are really, all joking aside, there really are some misconceptions here that people have. And the biggest misconception is, we use everything, we don't have any intellectual property, and to the extent we do, we use it for our business. Right? It's our trade secrets, and we just don't like to talk about it, but it's all there. No, it's not all there. Just separate it out. Let's talk about it. It's just like in the financial statements. You say, well, there's this account here, and don't worry about that. No. How much? Is it $1 million? Is it $100 million? We worked with a company called Broadcom. Its patent portfolio is worth well over $1 billion. However, it sold for $36 billion. So not really a big deal. Right? You don't want to upset the apple cart on a $36 billion deal over a $1 billion patent thing. But you do if it's $350 million you can get on patents, and when your other best offer was 100, right? That really makes a difference. And then there's the idea that, the buyer will just pay us for it. The buyer never pays for it. Why would the buyer pay for something you didn't specifically set out and you didn't demonstrate that it has some value, right? Our lawyers will tell us, right? Our outside IP counsel will tell us. Of course, they're brilliant, right? They clerked for the judges and they did this. They'll tell it. They know this infringement stuff. They can't tell you. You know why? Because 3/4 of the people that are infringing your patents are also their clients.
Not always true. Not never true either.
That's right. Right, but an investment banker can tell you because our rules are a little different, right? We can just take a look and say, hey, no, look, from a financial perspective, here's where you can make money with these. Here's the people who would be interested. We're not giving you a legal opinion. We're just telling you, here's the value of these patents, and here's who would be interested. Because they're infringing, because they have some battle in their own world because of whatever, whatever other reason. And then, here's this, my favorite is, if we monetize patents, we'll be a patent troll. That's a serious issue. So what happens is, you show up on NPR, you show up in the State of the Union address, right, if you hate patents, right, and you pay for these things. You show up in these couple of articles, you make this whole hoopla about patent trolls, patent trolls, patent trolls, and then slowly you're starting to affect people's decisions, right? So this talk here, you're paying attention. That's very nice. When I give this talk in Silicon Valley, I get heads turning and like, oh, yeah, another patent troll guy, like this, right? Because it's everybody bought it, lock, stock, and barrel, right? I have a friend whose son is a mechanical engineering student, senior at Stanford. And I mentioned what I do, and I'm in patent. He said, oh, you're a patent troll. So we started talking about it. I was like, no, patents are stupid, patents are useless. I was like, dude, you are literally going to be working at Walmart, right? Without patents, it's a race to the bottom. It's a race to the bottom. It's just free. Just imagine, everything is just free. Everybody just go in, just take whatever you want, right? That's the narrative that's there. So let me wrap up here. How, as a board, right? As a board director, what do you do, right? Now you've been educated, right? This is great. Okay, I'm gonna go home, make $300 million for my company. How do I do it? Well, you do some analysis, right? And you figure out there's really nothing there. Okay, that's a good answer. Now you've looked, right? Especially under Revlon, you can say, hey, look, business judgment rule applies. I did the right thing here. I have a duty to inform myself competently, and think about it. I did. There's nothing there. Or there is value there. Well, are they paying for it, right? Do I need to hold back the patents? We did this for Yahoo. So we advised the Yahoo board last summer, 2 summers ago, on not selling the patents to Verizon. Everybody thought they were going to be given to Verizon. We were hired by the special committee of the board to run a process, right, because of this. We educated them about all of this, and they said, fine, makes sense. We ran a process, we got bids, and we said to Verizon, you want the patents, you got to write 2 checks. You got to buy the business, and you got to buy the patents. They didn't want to do that, but at least we got paid for the license, right? They got a license to the stuff that we kept out because we didn't want to give it to. Why would you get this stuff that has nothing to do with you? Like that. And then, is the transaction, at the end of the day, is this incremental value, is it fair to shareholders? Is it material or is it not material? Right? These are things we should just talk about. There's nothing wrong about just talking about it. So how do you value it? Well, you got to understand the underlying technology, right? You got to understand the law, and you got to understand the finance behind it. And good news is lots of advisors and folks that can help you do this, that can be hired to do this. I built, my last company was an investment bank. I built this triangle here. So now at Houlihan, we have, there's 30 people on the team in the States and 20 overseas. More than half are engineers, right? You got to actually know what's happening under the hood. We got a dozen lawyers who came from big law firms, so we can do this stuff, and of course, finance folks from damages and others. Why? With this idea that there's a separate value that's under the surface, which in the case of MIPS, this was flipped. But in most cases, there's material value down here, material to the value of the deal that's there. So whether you're just running a company and want to generate extra cash for the company, or certainly if you're selling the company, this becomes really important. And let me end with this. Here's nobody makes money from patents anymore. Here's somebody you should know. That looks familiar. And a number of these companies that are just basically, you'll see them there in the semiconductor business, but there's no reason why this shouldn't apply in most other businesses, including energy, automotive, and a number of others. Great. That's it. Thank you very much.
So, I can understand 5 separate subgroups. That's a lot of complexity. 5 is way out. But aren't there situations, you talked about one where you might have 2 folks in that non-core business who are head-to-head, and sometimes they battle, but sometimes, frankly, that neither of them is interested in the other competitor. What they're interested in is possible disruptive folks coming in. They don't mind having one other competitor. What they mind is someone coming from offshore or otherwise at a tiny price point disrupting their business. Mm-hmm. In that situation, does it make sense to split up the technology into subgroups, give them each a right exclusively to it, but also keep a non-exclusive in the other party? They don't have to worry about each other, but they both have the ability to fight back against someone disruptive coming in. Would that still be ugly in your words?
Would it be ugly? No. No, you know why? Because what would be, well, it's gone. That's fine. What would be,
it's back up.
it might be, it depends on if these two companies are working together and they have a lot of market share, maybe an antitrust issue. And the DOJ is highly focused on this, right? This happens in patent pools, right? Where there's a lot of attention paid to that. Here, what I'm talking about is taking the same corpus of innovation, the exact same set of patents, and then splitting it up and then just attacking one competitor, basically, just attacking one person, and then doing it in a sneaky way, right? Doing it in a way where they're sued by all of these different companies, and you're just basically forcing them into the kind of the Napoleon-Russia battles, right? You just open 5 fronts with them, and they just say, okay, fine. They cry uncle, and they settle, but then they turn around and they say, look, these guys, we should have really paid them $300 million. They forced us to pay them $800 million. So we just spent $500 million on somebody's clever trick. Why don't we just spend $100 million in Washington and change the laws? That's the math. So that's why this is ugly, because it turns a normal effort of licensing and monetizing your patents into something that gives fodder for people to just say, okay, you know what? They're abusing the system, and we got to go. Which is basically the best thing to do is just destroy patents altogether.
Well, speaking of that, I mean, you clearly had a negative perception of the new patent office procedures that have come in place recently for challenging patents. Now, isn't it true that the patent office has kind of the technical expertise that a judge or jury would lack? Why not have the patent office make those decisions? What's the downside?
The downside is that a lot of those judges are appointed, I mean, I couldn't disagree with you more, right, on this, but those judges are appointed by the head of the patent office, who's appointed by the head of the Department of Commerce, who's appointed by the president. Right, so that's the problem. These agencies, this is not what we want in this country, right? We want separation of church and state, right? We like our Article 3 judges to be Article 3 judges because there's a whole system in place to do that, and we don't want the administrative agencies basically deciding the innovation policy of our country. We want Congress to do that. If we hate patents, let's go do something in Congress. Let's not appoint some administrative agency to have a kangaroo court inside it. I mean, look, 80% of the patents that they issue themselves, they later find invalid. So which group do you want me to fire, the court or the people who issue the patents? Because one of you guys is doing something wrong. 80% of your own patents. It's like stuff that I say to my wife that I take back, right? 80% of the stuff, I can't be right on both sides.
But isn't it true that with courts, you have a lot of difference in terms of how long it takes, how much the discovery cost is, whereas in the patent office, you have one schedule, it's set, it's over in a year and a half, so you don't have a lot of uncertainty over the board and the company, and you don't have a lot of the discovery costs, which is one of the big problems with the court system, is how much it costs just to have the lawyers sending letters to each other about who's going to get what information and who's going to depose who. None of that happens at the patent office. Doesn't that advantage outweigh the problems that you're identifying?
As with any government thing, right? In theory, it works great. In practice, it's a disaster, right? What really happens at the end of the day is you have the whole process. You can set any process you want. If at the end of the day your judges hate patents, and as a matter of fact, a lot of these things went up to the Federal Circuit, right? One of the things that the head of the patent office did is she stacked by the way, the lady who ran the patent office was the former head of patents at Google. So when Obama came into office, then she became the head of the patent office and selected these judges and ran these panels. And same with the FTC and same with the DOJ, right? All of the people who are enforcing antitrust laws and everything else, they're basically just placed there. And look at this net neutrality issue, right? It's a lot of these issues, they end up changing as the administration changes, and that's just not good for the business. Right? It's not good generally for the business, because what you don't have, the number one thing you need is predictability. You need to know that if you're going to spend, these are serious issues, right? You're GE, you're IBM, you're pick a company, you're going to spend $500 million developing some technology, you got to know you can protect that, right? It's the driver of a lot of our growth. And if you don't believe it's going to be protected, then you just go buy another burger chain, right? Or buy whatever, something like that.
Well, speaking of Google, now, certainly you're right, the tech companies are out there spending money on lobbyists, pushing to weaken patents, but isn't there also a huge section of the United States market, and we're not just oil and gas here in Houston, we also have the Texas Medical Center. Right. Those pharma companies, they're hiring lobbyists too, and their lobbying is going in the exact opposite direction. Don't we have kind of a balance of power up there in Washington?
we did for a while, and then they took a break. And normally, it's the pharma companies that help keep the balance of patents, right? You have the tech companies always want 0 patents, and you have farmers say, hey, look, we live and die by patents, and we got to find some compromise here. So then the tech company said, okay, well, let's just have 2 patent systems. Oh, that's a good idea. So what happened is, during the time that this big push came on the anti-patent side, all the pharma companies were caught up in Obamacare. Right? All the medical device companies, remember Obama imposed an excise tax? I come out of the medical device industry. I built 3 companies and sold 2, one to Stryker, one to Thermo Electron. And I thought we were just being penalized because we were small, and then when I went to work for Stryker, when they bought the company, I realized these guys are afraid of a government agency, the FDA, just like they're afraid of a patent agency, right? It just kind of changes as the wind blows. And at the time that the patent laws were going through, it was an unfortunate time in history of patents that the #1 defender of patents was fighting a much bigger survival battle. And they literally told us that. I talked to these guys and I said, look, we just can't do this. Right? I only have so much ammunition. I got to make sure this Obamacare doesn't kill our business. I got to make sure that I can't fight patents now also. So they're back now. They're coming back because what happens is under the new laws, you can challenge a drug patent also. And if you have an 80% kill rate, it's a kangaroo court. Right? Any court that has like 87% rate of going in one direction or the other, I mean, that's Jacob Zuma, right? That's whatever. That's like some dictator in North Korea, right? This is like some guy goes out and you say, oh, you're guilty or you're not guilty or whatever the thing is, right? It's just, if you can predict with an 80% certainty, those are good odds. What other place can you go and roll money like that, right? Nowhere.
Eastern District of Texas.
That's right. But yeah, good one. No, Eastern District of Texas just trying to bring some balance to the system, right? No, it was biased because people who had good patents and they needed to get a good hearing, they would go the extra mile to go to Eastern District of Texas, right? So yes, there's 2 sides to every coin, but I think it's once you set yourself up as you declare that that you're going to view patents, for example, in a fair and reasonable way, then people flock to you. They're not going to go to Northern District of California. We know what happens to patents there. They die, right? So people say, okay, where else don't they die? So now what's happening is all of the major patent litigation is in Europe, right? So we have all of our clients are suing or getting sued. We're on both sides of the issue, right? We're defending a bunch of clients and working with them on the other side. Google is a big client, right? So they take some positions that we don't agree with. They take other positions that we do agree with and support, right? There are people who do pigs get fed, hogs get slaughtered, right? There are hogs in the patent market that if something is worth $1, they want $10, right? Then we say, okay, no, that's wrong. Let's fix that. So what happens is now you go to the jurisdiction that makes sense. Once we eviscerated all of our jurisdictions here, people just go to Europe. Our biggest cases have been in the UK and in Germany, right? Because you can get an injunction in that country, and now at the European Patent Court, you may be able to get an injunction across all of Europe. But if you're Samsung, you don't want to get an injunction for Germany, right? It's a big market. You don't want to do that. So yeah, you can squeeze it here. It'll just show up somewhere else. So now we can say, well, Europeans love patent trolls. Well, no, they have the same issues that we do. Their system just doesn't swing wildly like ours does, right? There was a time in the late 90s, early 2000s where these literal patent trolls, they bought junk patents. They could get $100 million somewhere, right? They go sue somebody and get $100 million because they have injunctive risk, right? It's a serious issue, right? So you can stop somebody from shipping because there was an automatic injunction, right, on patents. But there's a case in the Supreme Court that eviscerated that. So I think we've fixed a lot of these things in the patent system. But now what we're doing is we're now cutting to the bone, right? We trimmed the fat. We cleaned up a lot of we eviscerated the patent trolls. Very good, very helpful. But now we're attacking real innovators. Right now, GE is struggling to get their stuff. IBM is struggling to get value out of their patents. Dolby, right? People are calling Dolby. I had a client called Dolby, who's another big client of ours, say, oh, Dolby is a patent troll. Oh, Dolby is a patent troll because you stole their stuff that they've been inventing for the last 50 years, right? And now they took you to court, and now they're a patent troll, right? Like that.
Well, I've heard Caltech called a patent troll as well, but so you told us that the Supreme Court's considering rolling back your favorite kangaroo court. Let's assume for the moment that come June, the Supreme Court in oil states says, no, the Patent Office can't have this patent killer court. And the boards now have a lot of value they need to deal with. a lot of your analysis starts with what is non-core? And how does a board member, we all, the regional managers of each business unit, of course, think their stuff is core and her stuff in that other business unit is non-core, and they all tell you that. How does a board figure out what's truly non-core? Do you have any advice for them?
I do. You work with the management team and outside advisors who can give you that advice. And take a look at your entire intellectual property portfolio. It could be brands, right? So one of our clients owns the RCA brand. You know, the little dog with the loudspeaker thing? That little puppy makes a lot of money. I can't tell you, but it's a lot of money. It's trademarks, and it's a side business for our client. Another one of our clients is Philips, right? They make Magnavox and Philips, the shavers and the TVs. They don't make any of that stuff. It's all licensed brands. So do you have a brand that could work in some other area? Can you license your brand to some other, like for example, RCA licensed its brand to a Taiwanese company that does tablets, that competes with iPads and others. So if you're RCA and you're thinking, well, we're kind of TV and audio and all of this, why wouldn't you license that brand somewhere else? Same with your patents. You may be developing an XYZ technology in oil and gas, and you figured out a way to communicate downhole, to get sensor data and all of that. So it's a harsh environment. Why doesn't that work in automotive? Of course it does.
There's this concept between exclusively giving someone your IP and non-exclusively giving someone IP. How does that play into some of the potential deals you talk about? And are there circumstances where one is better than the other? What is that really about? What is that distinction?
Sure. So exclusive just means I will no longer do it and nobody else will do it. I'll just give you the right to do it, right? I appoint you as the person who can go build X, right? That's the exclusive. The non-exclusive is I'll let you do it, but I'll let other people do it as well, right? Kind of the basic 30,000-foot distinction between the two. The exclusive is actually more valuable because it gives you the right to prevent others from doing it. And I'll tell you, patents equal profit. If you cut across all the different businesses, if you have the better mousetrap and you can make more money on it and you can keep your margin from eroding, right, which a lot of businesses do, like 3M and others that have fantastic products protected by patents and nobody can get in because you just sue them and you make sure they're out, then you have these 80% gross margin products, right? A lot of medical devices are like that, right? They're all 80% gross margin products. You're not competing like, I was in the construction business early on, actually did oil and gas stuff right here in Beaumont, refineries and all kinds of Kellogg, Brown and Root and all of that right out of college. And a lot of these businesses are operating on 3% margins because everybody else can do it. As soon as you have intellectual property, you're at 50, 80% margins, right? So if you run your business in a way that can get these high margins, either you invent your own technology and then do it, or if you have an abundance of technology and you're really good at innovating, not so good at marketing and taking to market, then you can license your technology to others to do it, ideally exclusively because you really give them a leg up. Or if you're a company that's just great at execution, just not very creative, then you can get a license from somebody to, and get an exclusive license from somebody, and then you do it. It doesn't have to be your stuff. So what? Not invented here. No big deal.
So we talked, and you talked about exactly what happens when there's a potential transaction and how to take advantage of the non-core IP at that point. But long before you get to that point, companies sometimes do collaborations or joint development with other companies. Is it possible for them to burden their own IP in ways that makes it hard to monetize at the point in time the transaction comes around?
Yeah, not possible, but likely. Right? People walk into these joint venture agreements and they take their standard corporate counsel to help write the agreement because it looks like it's a new business. It's not a new business. There's a ton of intellectual property that gets created, and if you're not very careful about who gets what, right? There's a concept called the background rights. So I have my background rights, and you have your background rights. Now we're going to get together, and we're gonna build this new intellectual property. Who owns what? Where's the bleeding back and forth? Who owns what piece? That confusion, if you don't do it right, will kill a deal. It'll kill an M&A transaction. It'll kill the entire deal. Because what does the buyer do? The buyer comes in, takes a look at this, and says, you're married to this other person, and I can't figure out heads or tails who has what. And I just can't deal with it, so it's too much complexity. And as you know, two things that kill deals is complexity and time. Right? So if they're going to take a long time to figure this out, it just kills the deal. So you got to, as a board, you have a real duty here to make sure that you've got the kind of advisors who know how to do this. The people who figure this out the best is the pharmaceutical industry. right? They really know how to do this. Joint ventures, joint development, sharing of R&D, licensing in, licensing out. But people in the semiconductor industry are kind of right behind them. But industrial companies, all of that, for example, new educational technology companies, all of the others, you're wide open to risks here, right? And you get suckered, right, a lot. You get suckered, by the likes of big tech companies who make deals such that you actually never make any money, right? Which I know you guys are grieving for having lost Amazon. Trust me, it's not such a bad thing.
So in terms of this question, you talked a bit about patent pools. Remember the 4G, the companies coming together, you had the implementers and you had the innovators, and they had this structure. So patent pools, though, is kind of separate from, say, a standards organization where companies come together and develop what is 4G going to require? What is 5G going to require? What are some of the risks involved in joining a standards organization? In the oil field, it could be the standard for using explosives downhole. I mean, there are lots of standards, and as you know from the medical device industry, lots of them there as well. What are the risks that someone on board should know about when the company is considering being part of that standards creation process?
Yeah. Well, first thing I learned when I came to Aurora, Missouri is if it ain't broke, don't fix it. So there are a lot of things that really work. And we see people try to innovate and have their own bright idea about how to do something that's it's really not necessary, right? A lot of these things are market driven. There's a reason why we have patent pools. Patent pools started with the sewing needles, right? Singer sewing needles, and back in the 1800s, that was the little first patent pool. Then it was in the aviation industry, and there's so many other industries. All of these things are market negotiated rates. People refuse to accept the fact that some people are better at innovating, some people are better at manufacturing, and some people are better at marketing. And there are companies you can put all of this under one roof, great. Lots of companies you can't put it all under one roof. So you got to have deals between them. And when you can have bilateral deals, like we talked about, exclusive, non-exclusive licenses, all of that. Or if you have 40 innovators and 1,400 implementers, then you got to have some kind of a many-to-many discussion, right? And it happens at two levels, like you said. First is when we're just building a new technology, do we want to standardize on this, right? To this day, we have the US system here, right, for our wrenches and everything else, and we have in Europe, we have the European system, right? And it's a pain in the neck, right? If you're in the oil field services business and you ship stuff like I did, you ship stuff here, or you ship stuff to Alaska, or you ship stuff to United Arab Emirates, then everything is different, right? Because there's no standards. Standards drive value. And there's always going to be hogs in that. There's always going to be people in that group that want all of that value for themselves, right? So step one is what technology will be in the standard, and step two is how do we share the money that's made by that standard? Who gets what? So the existing systems that work, the only time they don't work is when a group gets together and says we're just going to co-opt this, right? Motorola,
doesn't that work for the group?
It works for them.
Okay, well, works for some. I mean, some of our folks might be in the group. They might want to know how that works.
Yeah, well, there's two ways to win, right? There's one way to win on the merits of negotiating with the other party and say your patents are worth this much and my patents are worth this much. There's another way to win to say I'm just going to eviscerate the patent system. So I'm all for fighting down and dirty. I'm Bosnian, right? We know how to fight. And I'm all for fighting, but there's got to be some rules to the game. And some company wins, some company loses. These guys cry and whatever. These guys celebrate. Okay, next trial, the other guy wins, the other guy loses. That's fine. It's fine for your business. You always win. But what's not fine, where I think there's danger, is when you try to say, it's going to cost me $400 million to win, and I can spend $100 million in Washington and just eviscerate the system, right? Well, eviscerating the system really works for you. Good for you. Good job. It doesn't work for the rest of the country. It's really, really, really bad for our innovation, for our economy, for our jobs, for our kids, right? You put everybody else in the race to the bottom. And then they have so much audacity to go against our Constitution and say, yeah, Constitution notwithstanding, we're going to set up a kangaroo court that doesn't play by the rules of the Constitution or the patent law. It plays by its own little rules, right? That's what I'm complaining about, right? That's what I think the danger is. And one way to make sure that doesn't happen is for the boards to pipe up and say, hey, wait a minute. You just wiped $1 billion off of my balance sheet here. I have some real value here, which is what happened to all of these companies I mentioned. Technicolor, Dolby, GE, IBM, Philips, all of these, great Ericsson, Nokia, Motorola, Texas Instruments, right? That number I showed you is a little old for Texas Instruments, right? Their revenues are down by half, right? So why isn't somebody on the board of AMD or Texas Instruments saying, hey, time out. Why is Apple now building these chips that we used to build up until yesterday, right? They say, oh, Apple just brought it in. They didn't bring it in. Why didn't they bring it in yesterday? Because yesterday, Texas Instruments had patents. Today, we have the kangaroo court, so Apple just says, well, I can buy it for Texas Instruments for $5 a chip, or I can just build it myself for $1 a chip, because I'll just give it to the Chinese guy to build it for me. So that's what Apple does. What does Texas Instruments do? They say, wait, we have patents. Oh, go to the kangaroo court, talk to them.
Well, so the kangaroo court here in the US, what about what's going on in China? I mean, we've got a situation where, especially in the medical device area, diagnostic patents are now being attacked in the US, but are actually being upheld in China, which is seen by many people as having a stronger patent system when it comes to medical diagnostics than the United States does now because of recent Supreme Court cases going after what they call abstract ideas or laws of nature. Is China now a good place to hold your IP? Is that a good place to build value?
So I went to Shanghai a little while ago, and I received two shocks. One was when I saw how big and beautiful it was, right? And then I see the pictures before and after and all this. And the second one was that night in the hotel room, and I thought, we built all that stuff for them, right? Instead of building my town, St. Louis, where I effectively grew up, went to school and had kids and all of that, St. Louis is going like this, Shanghai is going like that. So nothing against China or Chinese people or anything like that. Great, hardworking people, good family values, right? There's no problem there. But why are we building their country and not our country, right? And that's so when you see that the patent system is just one example. It's in every other example, right? We don't have money for schools and roads in St. Louis, right? We've sold all the big companies in St. Louis that built the city, right? So Anheuser-Busch, gone. McDonnell Douglas, gone. Emerson Electric, almost gone. Right, Monsanto, gone, right? All of these companies that if you live in St. Louis, you have a free zoo, free science center, free science museum, free art museum, free history museum, free botanical garden, free everything. And, huge park, good quality of life built by these companies that were built on intellectual property, like Monsanto, right? They're big intellectual, they protect the seed, right, with intellectual property. And they've had some of the seminal cases in the Supreme Court, and they're fighting for patent rights and all of that. But now that's owned by somebody else. That's gone. And the money is going to be gone. Look, who's the smartest predictor? Somebody here said their son works on the PSLs. Our friend in the back there. On the personal seat license. Who knows about a personal seat license for the NFL? I was a sucker for one of those in St. Louis when we brought the Rams in, right? And what happened with the Rams? Well, they're smart. They do their demographic studies, and they said, this city isn't going anywhere. And they picked up and left. Right? And that's what I'm concerned about here is if you don't protect these industries that we have, we built all of this stuff. We invented all of this stuff. We continue to invent. We continue to have the best universities, the best startups, the best everything, but we're now promoting this, communist narrative of share everything. Open source software, open innovation, open this, open that. Yeah, open this, open that. St. Louis is going like this, and Shanghai is going like that. That's what it got us.
So Elvir needed a better attorney when he negotiated that PSL, by the way. So a lot of the companies in Houston have a lot of their IP in software, not necessarily patents. They may not have a bunch of engineers building physical things, but they may have a lot of software engineers building really smart software. And your slide showed the copyright-intensive industries is actually having a better trend upward than the patent-intensive industries. You're worried about kangaroo and courts and all that, but does that really have an impact where software is the big value for the company?
It's huge value. So I'm an electrical engineer. I did a lot of software. I could have been a software engineer within a hair's throw, right? It was really close. And had I been a software engineer, I wouldn't get any patents because we don't like patents for software because big tech tries to kill software patents because it's an abstract idea. Well, how is it? Is your phone abstract? It's not abstract. When you look up and see the weather and book your ticket online, it's not abstract, it's very real. It's very real. I really got on a really good airplane, and I flew here, all on software. So why do we penalize software engineers and give them no patent rights, and we reward mechanical engineers, and electrical kind of in between? Right? So I think that's a serious issue that that again, we just don't have a national conversation about it. I know we have bigger national issues to worry about, but from the economics perspective, man, you guys gave us a big boost here. Thank you very much. The country needs to write you a big thank you note for oil and gas revolution that's happened here. They haven't, they should. But that's going to run out, right? And we've had these other revolutions, right, that have propped the country up. But innovation has always been that one that gets us. And I think we're sawing off the last branch that we're sitting on ourselves by not really paying attention to these things. So I figured, spent a lot of time in Washington, total waste of time, because you just can't get anything done. So I figured, you know what, let's just go to the boards. The way to do this, why I wrote that paper, is let's go to the boards, because the boards have the power, very practical kind of people power, distributed power, to make these kinds of things and say, no, time out, we're not going to do that. Right? We're going to fight, we're going to do this, we're going to join this, we're going to make money off of this, let's trade these things, let's value these things, let's have a conversation about it.
When you're looking at the value in a company, the potential non-core IP value, do you analyze software differently than you analyze patented
Yeah,
IP?
we penalize software. Right? We give it an 80% discount off the top.
And why is that?
Because you can't get those patents. You cannot protect software with patents. There's a decision that came out of the Supreme Court, and Congress didn't do anything about it, which is what they should do, where basically the Supreme Court said, well, it's an software, it's kind of an abstract idea, I don't know, I just don't know what to do with that. So they gave no guidance to the district court judges, who now just say, oh, it's an abstract. I don't understand it, therefore it must be abstract.
So you don't think copyright protects software?
No. The copyright numbers, you can't trust. You're a lawyer. You shouldn't trust all the numbers I put up on slides.
Well, that 80% I'm really questioning, but I don't have my numbers with me, so go ahead.
So it's copyrights for arts and entertainment.
So you put Mickey Mouse numbers up for this crowd?
It is a Mickey Mouse number.
Okay, well, as long as we all
audience
know,
here.
right?
I'm sweating here. Can you get a different moderator next time?
So what impact does it have when foreign companies are buying United States patents and building a portfolio here only for defensive purposes? Right? They just have that portfolio because if they're sued, they want to be able to have something to throw back. Is that something that companies here should be worried about creating when they're doing a deal? You know, giving a company, I'm not necessarily China, South Korea, Europe. If those companies have US patents but don't have US operations, aren't those patents only there for offensive purposes?
There's two things on patent sales. There's the national security concerns, and we should be very, very concerned about that, right? Just shipping our technology willy-nilly to anybody, right? Our best stuff, giving it to everybody for the kind of the highest bidder, that's just dangerous. Nobody does that. It's just stupid, right? We shouldn't be doing that kind of stuff. So national security concerns aside, once you're in the markets, then fight it out with anybody. I think it's good to have competition, and it's good to, if they truly are, getting innovation, if they're going to buy some patents from, Texas Instruments is in some business, they're going to keep their core technologies, their non-core stuff they want to sell, they should sell it to the highest bidder. I don't necessarily see a problem there. Now, if those foreign companies are really here just to fight the courts, that's why we should just have the courts do this. The courts, on the whole, do a good job, right? You can abuse the courts, right? Like I talked about the Walmart slip and fall case, right? There's the patent slip and fall cases. Yeah, you can abuse the courts. But that's a small problem. It's kind of a risk we ought to be willing to live with, right? Yeah, there's annoyances, and when they get out of hand, like there was some patent troll that was sued by, and they sent 100,000 letters out or something to every coffee shop, right? Something ridiculous. So the state of Vermont went after them on some like racketeering law, right? So you can squash these bugs in 100 different ways. Don't squash the bug by killing the system, right? Talk about throwing the baby out with the bathwater. Same with foreign competition, right? I'm all for global foreign competition. Let's just play a fair game. If they want to go play an unfair game and try to block people in courts and all of that, then we should have the courts do that. We shouldn't just obliterate the patent system.
So when a board is looking at the value of two different businesses and trying to decide which one has IP value versus not, as a starting point, before they even kind of get into more of the detailed analysis, are there any things that you would say at a board level they can look for to make that judgment call? Any hot, kind of easy signals, as it were, for a board member?
The easy signal, patents are public, so when you file them, you let everybody know what you invented, and the easy signal is account. If you're buying two companies that are about the same, have the same EBITDA, pretty much in the same business. One has 5,000 patents, one has 300. Buy the guy with 5,000 patents, because that guy's going to maintain his margin and the other guy won't. It's very simple.
So I really, really appreciate you're listening to two electrical engineers talk in front of you, because as a general rule, we don't get good audiences.
That's right.
So,
We're so excited.
And questions as well. So we're very thankful for having a wonderful audience this morning. Thank you for your questions, and I hope you enjoyed the presentation.
Thank you very much. Great questions. Thank you. I really appreciate it.